All right, so after we have acceptance, remember this is all part of an agreement. So you have to have the offer and the acceptance. The agreement has to have this meeting of the mind. What was the clear intent of the parties? If there is any ambiguity, the court can cancel the contract or help interpret the contract based upon the parties' intent. So always looking at what is the intent of the parties. Then from there we go to communication. This process of offer and acceptance needs to be communicated. In some cases, silence can mean acceptance. So if I offer to paint your house, and you're like, okay, and I tell you it's going to be $500, and you don't say anything, and I go there and I start painting, and I paint 3 sides of your house, and then you come home and say, no, I didn't agree to this. You know, I didn't agree to this color, I didn't agree to the price, or I didn't agree to anything. Should you have reasonably known? The courts don't like what's called unjust enrichment, where someone gets the better bargain of a deal by trying to claim, okay, there wasn't a contract, or I didn't know what the terms of the contract were. If something benefits you, the courts are really going to say you accepted the terms of the contract, just by your action. I mean, if they were there and you saw them there that morning, setting up, taking out paint cans, you can't just say, well, I didn't know what you were doing. You know, the courts aren't going to say that you're a complete idiot. They're going to say you knew what you were doing and you were trying to hurt someone. When you sign something through this communication process, normally you'll sign something and it will say, Gil Fried, President. Because you don't want it to be Gil Fried, Janitor. Because does the janitor have the power to bind the organization? Normally not, right? Unless it's a janitorial company, maybe the janitor can bind the company. But you want to make sure that the right people have the authority to bind. So if you have a player who signs a contract to play in professional sports, and then the person from the equipment room signs the contract, do they have the power to really bind the organization? No, they don't. So that's why you often have that, who has the authority to bind? Because if you don't have the authority to bind, the court can cut back and send back the contract saying, no, it's bad. So this is all within this concept of agreement, the first element of a valid contract. We have agreement, consideration, capacity, legality. So the next area is consideration. Every contract needs an exchange of value. It could be anything you want, whatever you feel is valuable. And so oftentimes you'll get a contract that says, for the sum of $1, which is hereby attached, you agree to X, Y, Z. And if I accept that dollar, fill out whatever they ask me to do, it's a valid contract. Because I accepted the dollar. You can't come back later on and say, well, that dollar wasn't really meaningful to me. If you accept it, tough luck. And that's why they often have that kind of clause in a contract. Now, what about inheritance? If, as I said before, if you do not need to do anything for the inheritance, it's just like a gift. There's no consideration. Consideration is exchange of value. Always have to have some kind of exchange of value. So if you have that Aunt Bessie who's willing to put you in her will, or willing to give you a gift, and she changes her mind, tough luck, you don't get anything. If you change what you're doing in response to that offer, then that is valid consideration. We're not going to give value. So if she says you can't smoke pot, you know, for a year, but you go to school in Colorado and it's legal for you to do that, by abstaining from smoking pot during that time, you've in fact given something of value. And she would have to give you the inheritance or the gift. There is no consideration for past acts. So it's like, Professor Fried, I learned so much from you. I want to give you $1,000 for what you taught me 10 years ago. It changed my life. I'd be thankful for you. I'd accept it. No problem at all. But that's not exchange of value, because I've already given you something. That was part of my job back then. I gave you something of value. You accepted it. You gave something of value back to the university tuition. There's no more agreement here. No more consideration, nothing exchanging value. The same applies if it's a police officer, a firefighter, or something else. If they go into a house that's on fire, they can't go over there and say, you know what, I really want to rescue you, but let's enter into a contract. I'll take you out of this building if you give me, yeah, bless you, if you give me a certain amount of money. Because that's part of their job, the court will say, no, that's not valid. That's not valid consideration. All right. Next is capacity. Do the parties have the ability to enter into a contract? Well, if you're under the age of 18, if you're intoxicated or drugged up, if you're insane, as we said, the court justifies that, you can still enter into a contract, but it's voidable, which means you can back out of it. Not, let's say I buy a car from a car dealership and I'm 17 and I wrap it around a utility pole. I could bring back the keys to the dealership and say, look at, you know what, I was an idiot, but you sold it to me, I'm underage, I want to void the contract. Now if it's for essentials like food, I can't go and buy water and drink it, that was good, and then give it to them and say, I want my money back, because that's considered essential. So that would still be a valid contract, you can't void it. But if it's not essential and you're underage or you're intoxicated or drugged or insane, you could back out if you are the person that is a minor, intoxicated, drugged, or insane. Now, what if you have a parent that co-signs? That changes things. It still doesn't mean that the contract is not voidable for the minor, but normally means that the parents say, I agree to this and I will pay if there's any problem with the car, or if Johnny doesn't pay, or if Johnny backs out of the contract, I agree to the terms of the contract, and that's what you do. Now, what if it's a waiver that you sign for a kid to participate in sports? It normally waives the rights of the parents. In some states, it could waive the rights of the minor, but normally it just waives the rights of the parents. The minor, when they reach 18, they can come back and often sue and say, look at, my parents signed it, I didn't agree to those terms. It was a void contract, I didn't accept it, I want to be able to sue you now. And so that could be an issue, so that's why you try providing as much defense in those waivers as possible to say, if a parent signs on this, they waive their right, and if their child ever sues in the future, that the parents will hold us harmless and indemnify us and blah, 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 blah. So you can try putting, that's part of the deflect strategy of risk management, put the burden back on the parents if possible. Legality. If the contract covers an illegal matter, such as selling drugs, no court would enforce that contract. I can just imagine a drug dealer going to court saying, look, I sold someone some crack cocaine, they didn't pay me, I want legal remedy. Hopefully there's no one that's, take that back. There probably are people that stupid, but the courts will say, no, we can't handle this because it's a legal topic, it wasn't a valid contract, and by the way, welcome to the district attorney, and they're prosecuting you for criminal sale of narcotics. If the contract originally covered a legal matter, which is now illegal, the contract is void, it's no good. So oftentimes you have a clause in a contract which is called the legality clause, which says if any terms of this contract are deemed illegal, it does not invalidate the rest of the contract, only that provision. So if you had a clause, let's say allowing gambling at your facility because you're in Vegas, and now all of a sudden Nevada changes their law, that provision would be under those terms invalid. It doesn't negate the rest of the contract. All right, void and voidable contract. A void contract is not valid and unenforceable. From the very beginning, it is bad. In contrast, a voidable contract is one where one of the parties can back out for whatever reason. It could be fraud, undue influence, lack of meeting of the minds, whatever it might be. And that's what we call a voidable contract. Most contracts are not voidable unless someone does something wrong. And then the other side can often sue for breach of contract. The next topic is promissory estoppel. If someone entices someone to enter into a contract, the other person takes steps in reliance to what was promised, and they try backing out, the court will say, no, no, there's a valid contract here. Now, there are a number of different contractual terms that are out there. This is just one, promissory estoppel. There's unjust enrichment, as we previously discussed. These are all strategies that the courts use to avoid harm to people through a contract. If a contract is written in such a way that it punishes the average person, and the average person wouldn't know that, the courts will not uphold that. Courts want plain English contracts, as it's called. If you have all these double negatives and things like this, there's actually, the state of Pennsylvania has a plain English law on the books that say if you write a contract and it has double negatives, it's hard to read, people don't understand it, the court will automatically strike it down in favor of the consumer. Remember, courts have the power to use public policy kind of power. So if you go and buy Coca-Cola and you're paying $10 per bottle for Coca-Cola, and it's because there was a natural disaster and there isn't access to water or drinks or things like this, the court can come back and strike that down saying that is an adhesion contract, that is a violation of public policy. So even if it's legal to charge $10 per bottle, the court could come back and say, look, that's just not right. So what options do they have? The last slide that we have here, if you breach the contract, well, if any party does not comply with the terms of the contract, this is why you want to have a clause that indicates what should be the punishment. So do you tickle them? Okay, you breach the contract, I'm going to have fun, I'm just going to tickle you. No, most of the time, if there's a breach of contract, there is financial harm. So if you tried to get Gilfried, the 7-foot-tall basketball player, and they tried putting instead little old Gilfried professor who can't play basketball, what are they going to do? They're going to want to force you to comply with the terms of the contract and have the real Gilfried basketball player show up. That's compliance with the terms of the contract. You can also put the parties back in the original position, like the contract never happened, but if they spent money marketing Gilfried, the 7-foot-tall basketball player, and did all this advertising campaign and sold all these tickets, they've lost a lot of money. They should be entitled to that money back because that was reasonable for us to anticipate they'd incur those costs. Equitable remedy, what is right. Expectancy damages, what the other party expected. If they were thinking they were going to get millions of dollars from having Gilfried play for them, and now he's not playing for them, they might have all these damages that should have been expected. And the damages clauses, they could have one that's called the punitive damage clause, which is designed to punish. You can't really say it's to punish, but that is the intent. You can have a clause that if you come forward and finish building the stadium by February 1st, you get an additional $10 million bonus. If it isn't finished on February 1st, for every day that it's late, we charge you a penalty of $100,000. The courts will accept that. That's reasonable, and it's a contractual term, and a lot of contracts have that as a way to help speed up the construction process. So that is a quick overview of some of the legal issues dealing with contract law.